Okay, so good morning. Welcome, everybody. I want to say thank you to Crescent Care for hosting us here for this workshop. My name is Liz Dunneback, and I am the Executive Director of WAKE, and WAKE is a 501c3 nonprofit that was formed in 2020 here in New Orleans to help people deal with death and dying. So we have a mission to provide education and resources to the community for meaningful, affordable, sustainable death care. Often people ask, what is death care? And I think the easiest way to think about that is that it is a component, is an aspect of healthcare, a very under-resourced aspect of healthcare. It's non-medical support dealing with all aspects of death and dying, both before, during, and after death. It entails work such as advanced care planning, which we'll talk more about today, but this is work that can be started at any time in life and ideally should be started. It's really never too early to start planning about the inevitable. It includes talking with one's own friends and family about death, and also taking care of some legal and logistic steps to plan for end of life. There's no experience required, and I like to say that death care work ranges from the most profound work to some of the most mundane. Everything from understanding people's spiritual preferences, emotional preferences for end of life, and all the way through closing out credit card accounts, magazine subscriptions, cell phone accounts, things like that. Death care involves many different people from many walks of life, so it often involves the medical industry, the legal industry, the funeral industry, friends and family, and often clergy as well. So at WAKE, we help people who are dealing with death and dying, and we created the Louisiana LGBTQ plus end of life guide, and Ezra is going to talk a little bit more about the guide and why we created it. I can cut in between these parts and do a little slap shoot in between.
So we created this guide because a need became very obvious throughout my journey in funeral service. When I first started a relationship with my wife, who is trans, we experienced a wild amount of negativity through our families, and I became honestly very worried about what would happen if one of us were to pass, if we would get a say in each other's end-of-life plans or custody of each other's remains. And it became a real concern of mine. And so as I started my journey in funeral service, I began to ask a lot of very specific questions to the professionals that I encountered. And I learned that there were not a lot of clear answers, and there weren't a lot of resources available to the queer community. So we decided to create this guide to fill that need. Most of the information available in funeral service is geared towards heterosexual couples and nuclear families, but people in the LGBTQ plus spectrum experience estrangement typically, or non-traditional family structures, and it leaves a lot of room for things to go wrong when people aren't educated on what needs to be done when you're making your end-of-life plans. When you make end-of-life plans, it can save you from a lot of heartache and frustration, and so you need to consider your wishes and figure out what needs to be done to carry them out. And sometimes there are a lot of specific steps that are overlooked, especially in the cases of LGBTQ plus families, such as, did you know that you're not supposed to put your end-of-life wishes in a will, or that your pre-arrangements aren't protected by the state? So if you pre-arrange and somebody who's your legal next of kin who disagrees with your choices winds up being the one to handle your funeral, they can choose to ignore those wishes. There's several ways to protect yourself. Nick is going to tell us a little bit about the medical and financial aspects, and then I'll go into the funeral aspects of that.
And Ezra, do you want to I forgot to advance the slides. Do you want to just advance the next slide really fast?
My name's Nicholas Height. I am an attorney here in New Orleans. Gonna talk, like Ezra said, about some of the advanced planning that folks can do. And like Liz said, it's never too early to make some of these plans. At the outset, I'm obligated to give a little warning. I am an attorney, but this isn't legal advice. It's just information. If you have legal questions, you really should talk to an attorney who can give you legal advice. So when we talk about advanced planning, broadly there's three sort of categories. There's medical planning, there's financial planning, and then there's personal planning. So with regard to medical advanced planning,
Do you want to know?
sure, thank you. We can kind of lump all of that under the umbrella term of advanced directives. So any sort of direction that you can give about your medical care in advance of the time that you need a certain kind of medical care. So that can include a medical power of attorney. So that's a legal document that can basically say, if for any reason I become unable to make medical decisions on my own behalf, this is the person that I want to have the power to make those decisions for me. Another document is what's often called a living will. Some people still refer to it as a DNR, right? So a living will is basically a document that says, again, if for any reason I'm not able to verbalize what kind of care I want for myself, medical professionals can rely on this document. And a living will typically includes information about whether you want life-sustaining treatment, whether you want medical professionals to engage in sort of every option in terms of keeping someone alive, and the variations within that. The last thing under medical is what in Louisiana is referred to as an LA post. This document is specifically for folks who are at a phase of their medical care where a DNR, a do not resuscitate order, is much more likely to be an integral part of the type of care that they get. So folks who are potentially going into hospice, that sort of dynamic, you can execute this LA post document. It then becomes part of your medical record, so it becomes sort of a much more binding medical order that a doctor has to follow, sort of akin to a prescription in that way. And so that's sort of, as we move closer and closer to, as Liz described, sort of the inevitable conclusion of our life, right? The LA Post is perhaps a document that folks would want to have regarding their medical care. Financial planning. So all of us have things, all of us have stuff, all of us have possessions. When we're not able to make any decisions about how that stuff is handled anymore, somebody else has to do that. So one of the advanced plans that we can make is sort of, again, we can make a financial power of attorney. And in the same way that the medical document works, it basically says, if I'm not able to make the decisions or to be responsible for my finances or my material things, this is the person that I want to be empowered for that. The thing to remember about either a medical or a financial power of attorney, those are documents that are effective while you are incapacitated for whatever reason, but still alive. So, if you are hospitalized, if you are undergoing some sort of care that makes you unable to handle these things on your own, and you need somebody else to do it, but you are still living, a power of attorney is the document that you can use for that. A will or a trust is a document that comes into effect after a person has died. So a will is probably the most common thing that folks have heard of and know about. In its simplest form, it's just the instructions for folks to dispose of whatever possessions you have after you've died. A trust is the same sort of thing. It's slightly more complicated. It is more useful for folks who have a significant financial estate remaining after they die. Effectively what it does is it transfers all the possessions into an account or a financial setup in which one person manages all of it, typically for the benefit of another person. There's tax benefits to this, but again, those benefits usually only come into play if you've got significant several $100,000s worth of valuables in your estate. A living trust is the same concept, only it's something that you can execute while you're still alive. So you can place all of your possessions into a living trust, and as long as you're alive, you're in charge of that trust, and you can use everything the way that you normally would. But as soon as you die, the trust then rolls over to whoever you have identified as the recipient of the trust or the new trustee, and then that person seamlessly takes up the possessions that are in the trust. Again, there's potential tax benefits to this. It also eliminates the need to go through court to open a succession and to sort things out that way. But again, this is really going to be most useful for folks who have significant valuables in their estate, several $100,000. If you have $125,000 or less in your estate, then you're going to be eligible for what's known as a small succession. And so that is technically a court process, but the process is really just a single affidavit that gets executed that includes a list of what all is included in someone's estate and why it adds up to less than $125,000. That gets filed so that anybody who has any sort of claims on the estate can be notified about that. But you don't have to go through the whole process of notifying next of kin in the same way, of getting a judge to approve disposition of certain assets in the same way that you would if there's a will or not, and a larger estate. So again, $125,000 is the cutoff for that. So, you know, the general sort of broad rule of thumb is if, especially in the way prices for homes are now, if you don't own your home, you're probably going to be below that cutoff, since a home is usually the largest asset that most people have. So if you don't own your home, you're probably going to have a small succession, and so that's just something to keep in mind. The next sort of section of things, and Ezra touched on this, is what I think of as sort of like the more personal component. All of this, you know, if you're pre-planning services, the rights of disposition, that sort of thing. That's definitely Ezra's field of expertise, so I'll let them take care of that. The last thing I'll say though before I hand it over is that when it comes to the medical, the financial, and probably also some of the personal planning, maintaining that document, maintaining that information is going to be really important, right? Because, you know, the simple example is I write a will today and I want my best friend Joe to get all my things. You know, 2 years later we have a falling out and he's not my best friend anymore. But if he's still named in my will, he's still going to get all my stuff, even if that's not maybe what I wanted to happen anymore. So keeping those things updated, just like you do all your other sort of common paperwork, you know, is a really important part of it. But with that, I'll hand it off to Ezra to talk about the rest of this.
So there's several documents that you can address when you approach funeral and personal planning.
Do you want to advance the slide?
I'm still talking about
Oh, sorry.
So there's several documents that you can address when you approach personal funeral planning. You can start putting a death plan together at any time. You don't have to fund pre-arrangements. You don't have to have a funeral home chosen. That's going to be as simple as making your wishes known, writing them down, making sure that the people who are close to you know what those wishes are. And then that can go as far as choosing a funeral home and pre-planning and pre-funding services. Sometimes there's financial benefits of doing so. If you're in a stage in your life where you know where you're kind of going to be when you pass, what city you'll be in, sometimes it's worth it to choose a funeral home and make those decisions if you have the funding to do that. Usually you can save a lot of money because prices do change. You can self-authorize your own cremation if that's something that you'd like to do. And then you can also assign your primary right of disposition to somebody. So that is saying that you are choosing somebody to have the rights to your remains, and that person is not who would be legally designated as your next of kin. So this is a really important document for people who deal with things like family estrangement or are unmarried, or want their friends to handle their disposition instead of their family. And that kind of goes hand in hand with self-authorization and pre-planning, because as I mentioned earlier, your pre-arrangements are not protected. So even if you self-authorize your own cremation and pay for it ahead of time, if you don't put somebody in charge of your disposition who's going to respect those wishes, they can choose to disregard those wishes and change your plans and use the funding that you set aside. And then another important thing to consider is going to be your name and gender marker. If those things have changed throughout your life, you're going to want to make sure that all of your documentation is correct. And when it comes to gender marker, you're also going to want to make sure, if you are at an end of life stage, that your medical team is aware of your correct gender marker and that they're going to be compliant with that on your death certificate. We've learned while writing this guide that it really does sometimes come down to the doctor that's signing. A lot of that has to do with what's in your medical files and what's in your insurance. So it's definitely something that you want to address ahead of time if you have the opportunity. So there's a couple things to consider when a death occurs. Custody of remains is really important. So the state of Louisiana requires that you hire a licensed funeral director to handle disposition. Whether it's a direct cremation or a full funeral with 1,000 services, you are required to hire a funeral director, and they will be the one who files your death certificate. But you also need to consider who's going to be the person who has your right of disposition. So who's going to have custody of your remains in regards to who has a say. So again, if you are concerned that the person who would be legally given that right is not going to be somebody who respects you, then there are steps you can take to make sure that that doesn't happen. A lot of times it also comes down to finances. So unfortunately in funeral service, money does sometimes make the rules, and you may put somebody in charge of your arrangements, but not give them the funding they need to carry those out. And in situations like that, unfortunately, sometimes the choices do fall back to legal next of kin if they are the people who can fund your disposition. So that's definitely something that you want to consider as you move forward in your life and start thinking about advanced planning. If you're going to put somebody in charge, you also want to make sure that they have all the resources they need to carry out your wishes. You need to really consider what your final wishes are. Are there any special steps that you need to take? What do you want put on your death certificate? Maybe some of that information you feel specific about. Considering your legal name and your gender marker and the doctor who's going to sign your death certificate, and making sure that your end-of-life team is on board. And then in regards to death certificates, people who are going to receive a death certificate are going to need to prove kinship with the state, or they're going to need to be the person who handles your arrangements. So if you have somebody handling your final affairs, settling your estate, your will, and things like that, you want to make sure that they are able to receive a death certificate when you die so that they can carry out those tasks. But another thing to consider is memorializing. So even if legal documents and death certificates and things like that aren't necessarily going to read the way you would prefer them to read because of legal reasons, you can still be memorialized any way that you like. So you can have any name on your tombstone, any name in your obituary. Anybody can hold a memorial for you, even if they don't have your remains. We don't always have the resources to make sure that the person who would be our legal next of kin does not get a say in our disposition, but that doesn't mean that our friends and our loved ones can't come forward and remember us in a way that we are happy with.
So, Ezra did a great job of talking about one component of the things that can happen or that can be necessary when a death actually occurs. I'm going to talk about the legal side of this. And some of these things we touched on already, but I'm just going to go through them more specifically. The things that an attorney or a court is going to look for, when a death occurs, first is if there's a power of attorney, and in Louisiana, those can come in a variety of forms. You can have a durable or non-durable power of attorney, which basically means the power of attorney exists while you have the capacity to participate in the process, or it can extend when you have lost that capacity. There's also now what's known as a springing power of attorney, which basically says you can sign the paperwork for the power of attorney while you have capacity, but it doesn't actually come into effect until you become incapacitated for whatever reason. But again, The power of attorney, like I mentioned before, it expires upon a person's death, but it may have information in it about who an attorney or court or even a funeral director should look to, who may have additional information, who may have additional documents about end-of-life plans or advance directives or dispositional decisions that a person may have made already. The next, like I mentioned, is a living trust. So this is something that is made during life to avoid probate, to avoid having to send a person's estate through court. But like I mentioned, it's really only most useful for large or complex estates because of the degree of legal and financial and tax sort of steps that it can require. It's really most useful for large or complex estates. The most common sort of document that folks know about is a will or a trust. It specifically serves for ensuring bequest specific wishes to dispose of an estate. I have on here that it's to dispose of an estate worth more than $125,000. So it absolutely applies in that scenario and is typically the only real sort of tool for final wishes for bequests of an estate over $125,000. But if you have an estate that's smaller than that, it is still useful to have a will. A will still serves a purpose. The will, like I mentioned earlier, is a document that is intended to allow a person to continue to have some sort of say and some sort of control over their own self and their possessions, quite frankly, even when we're no longer physically able to do that, right? It is an instruction, it is a guide for the folks who we wanted to have participate in our sort of final moments together. It is in many ways, from my standpoint and my experience, one of the kindest things that we can do for our loved ones is to give them some guidance and how to proceed and how to sort of fulfill our wishes and be most respectful for us. So the will can include things as simple as, who gets my books, who gets my furniture, who gets that sort of stuff. That's very typical. It can include specifically saying who doesn't get anything, right? Because the Louisiana law, like a lot of places, has this presumption that biological relation, biological next of kin should be presumed to trump everybody else that we have in our lives in terms of claims on our things and on ourselves. And so it's entirely possible for many folks that we don't want to just adhere to that strict sort of, if I die, then the next person in line is going to be my kids or my parents or my siblings or whoever it may be that is available. I may have other people in my life that I specifically want to be in charge of disposing of my material things or receiving them in a certain way. And a will is really going to be the only way that you can meaningfully do that. So it is worth the time and the effort and the sort of emotional effort to sit down and make that plan to ensure that what you want to have happen is going to happen even when you're not able to sort of boss people around anymore. For me. If you have a small succession, like I said, $125,000 or less, a will is still useful. You're not required to have a will in the same way. I say required from an attorney standpoint. My thinking is if you have more than $125,000 and you don't have a will, that's a problem that really needs to be considered addressing, because it's just going to make things very difficult for everyone and it results in a sort of long drawn out legal process. But if your estate's $125,000 or less, and I keep saying that number over and over because it's just a really important sort of guide for folks, and I think so many folks don't even realize that this option is available. You can still have a will, and the will is still useful in terms of guiding who is in charge of disposing of things, who receives what, who is excluded, all of that sort of stuff. But if you have this small succession, like I mentioned earlier, all it requires is a simple affidavit, a simple accounting of what exists, what bank accounts, what credit cards, those sorts of things. All of that gets submitted in case there's anybody out who wants to try and recover on their debts against your estate, and that's it. So the last thing, and I think this next slide's maybe a little bit redundant, but it does have a piece of information on here about winding down an estate. So the thing to keep in mind, whether you are making plans regarding your own death, or if you're thinking about what role you may play following the death of someone else, any estate, large or small, is going to require a degree of winding down, right? And so what this phrase means is, it is not so simple as it is made to appear in TV and movies, where someone dies and you just go and you take all their stuff and you take it to your house and that's the end of it, right? We live in a world, and we all live lives where, to a certain degree, we have some sort of debt, right? We have student loans, we have credit cards, we have medical debt, we have car notes, we have something, right? The vast majority of that debt is not going to expire when we die. And so it has to be dealt with somehow. Student loans are largely an exception to that, so there's that. But credit card debt is a super common one. Mortgages, car notes, these are super common things. Some of the things, cars, for example, if you don't pay the note, they take the car back, which may be fine. If the person has already died, you don't need the car. If, however, I have inherited the car, and I really need the car, and I want to keep the car, I also am going to have to figure out what to do with the car note that also has to be paid. It just doesn't automatically become free and clear just because the person has died. So things to keep in mind is that, you know, we may try our hardest to make plans and sort of anticipate as many things about the end of our life as possible, but it is important to remember that there is the very real possibility that there will be unfinished business, right, as the phrase goes, to a certain degree, which is why it's really helpful to have these documents in place, to have an identified person whose responsibility it is to handle some of that business, to talk with that person in advance to make sure that they know that they are given this responsibility and that they want this responsibility and that they feel capable of doing that, so that you don't sort of surprise someone with this and then they don't want to do it and then they just sort of pass the buck to someone else and maybe it doesn't happen the way that we wanted to. So again, you know, I think the theme to all of this is about the power of making plans in advance and how important that can be. And so I think Liz is going to talk specifically about exactly what some of those next steps after all of this can be.
Can I ask a quick question while we're on this subject?
Yeah.
So because this happens a lot with our clients. So to your point about debt, a lot of times I'll be contacted by somebody whose parent has just died and they're living in that parent's house. And that parent has a note, a mortgage. And so I'm trying to figure out, you know, how to connect them with legal resources. And one of the things I try to advise them about is about small estate succession. How do we ascertain what a home's value is quickly? Are we trying to get you know, are we looking at property, like tax records, or, okay, so that's legally what they're gonna go by?
I mean, if there's a mortgage on the house, typically whatever that number was that was used to sort of establish the value in the mortgage is the number that folks are gonna go by. If it's a home that's paid off entirely, then it becomes trickier, and sometimes folks just use property tax records, which is very convenient because that number is usually far below what market value is, and so it sort of helps us scoop closer and closer to small succession and the ease of using that process. Really, that number, the value of the property, the value of the home, is going to become an issue when you have folks disagreeing about how this is all going to get disposed of, right? So I want to go through small succession because I want to use the lower value of the house. You know, my best friend's sister wants the house, and so she wants to use the larger number so that we have to go to court and fight over it, right? That's usually the dynamic that you see, but if you don't have that kind of conflict, it's either going to be the mortgage because that's a pre-existing value number that's out there, or it's most likely going to be the property tax value.
Okay, great. And then the other question I have about that is, am I correct that when it's a small estate, it does not need to go through the courts?
Correct. I mean, it is a legal process in that you have to execute an affidavit, you have to file that, I believe it gets filed with mortgage and conveyance, just to notify the folks who manage property taxes and liens and debts and all that sort of stuff. But it doesn't go in front of a judge, it doesn't get a court case, it doesn't have to do all of that. But it is a legal document that has to get filed into city records.
Got it, thank
Yeah.
you.
Yeah.
Can I use those notes?
Oh, absolutely.
Thank you. Okay, so. So what can you do now? So, as I said before, it is, I think this is the third time we've said it now, it is never too early to start planning for the inevitable. Everyone dies, we're not getting out of this alive. I think Nicholas went through some of the really important steps for which you can engage a lawyer and should engage a lawyer. But there are a lot of resources available that are free, and we really encourage everybody to avail themselves of these. So I would like to click for a second on this link. There is a website with a lot of resources available for people at the end of their life. Okay, so the primary right of disposition is how we've been referring to a document which is technically called a Funeral and Disposition of Remains Directive Declaration. And as you can see, it's a pretty simple form where you basically appoint the rights to make decisions about your body, what happens to your body after death, to whomever you choose. So we talked a little bit about legal next of kin. In the state of Louisiana, legal next of kin falls primarily, first and foremost, to anybody who has a form like this completed. So whoever they've designated, this document trumps all others in terms of who gets to make decisions. In the absence of this document, and most people don't even know this document exists, much less have one in place, the legal next of kin, the decision will fall to, in order, a surviving spouse, a majority of adult children, a majority of adult grandchildren, surviving parents, surviving adult siblings, or a majority of the surviving adult persons respectively in the next degrees of kindred. So that goes to cousins and extended family. So it gets pretty convoluted, but as we've touched on before, next of kin can be estranged family members that you haven't spoken to in years. And so if you really want somebody else to make these decisions, this is the document for you. As you can see, it's really simple. You make decisions about how you want a disposition to happen for your body. So do you want to be cremated or buried, or there's a place up here for you to write in whatever you may wish for, and it just gets witnessed and it gets notarized, and that's as simple as that. And I want to just reiterate a point that we brought up before. All powers of attorney expire at death. So you may have put all this legal paperwork in place, that some of which Nicholas has talked about already, getting your life partner or your friend or your chosen family member the right to be able to make decisions about you in life, all the way through when you're incapacitated, as you're dying. Your DNR orders may be in place, you may have somebody else making those decisions for you, but as soon as you've died, then all of that legal designation is out the window, and this is the form that you would need. And then the other form that's touched on today, that's a simple decision-making tree for end of life, is your living will, and this is an example of a living will. We have documents ready to actually execute today if anybody wants, and this is the time we've designated for questions. Does anybody have any questions? I have another question for you, actually, Nicholas. Maybe I'll go get in the chair.
Yeah, okay, and I'll come up here and answer.
Okay.
So, in my own experience of being with people who were dying in a hospital setting, and there was a lot of pressure from the medical personnel for them to fill out like DNRs. And in every single case, even where people I knew who had before in life had been like, absolutely, I want to sign that thing, I don't want, somebody trying to keep me alive. It was interesting because in every case, and this was 4 different people, they kind of hedged at that moment. So I can see that this is going to be a common occurrence. So what I was able to do, and these were 3 different states, what I was able to do in those states, none of them were Louisiana, was to say, because we had been given this, whatever the medical power of attorney was, my sister and I, or whoever, we were able to say, look, because I remember, so for example, in this one case, my dad was like, I want them to try once to revive me, and then if they can't, let me go. And the hospital was like, yeah, there's no such thing as try once. Like, you either have the thing of this or not. And so finally, and in my case of my brother, he was so stressed out by this document being put in front of him. I was like, look, can we, and in that case, it wasn't me making the decision, but his ex-wife, who he had given this right to. I was like, can we just say, we'll make the decision. We're not gonna prolong life. But if this person's unconscious, can we make that decision for you? And they said yes. So I guess my question is that true in Louisiana? If you do not have a DNR signed, but you have given somebody else the medical power of attorney, can they make that choice as soon as you're unconscious? Can they say pull the plug or whatever?
Yes.
Okay.
So I think, it's slightly more nuanced than that, but only slightly, right? So the medical power of attorney is going to be sufficient if, for whatever reason, the person can't participate in their own medical care. The nuance of this, right, is if it is an emergency dynamic or it is part of a prolonged period of medical care that is perhaps culminating in a moment of making decisions about life-sustaining care, right? When we talk about an emergency dynamic, functionally, it is often very difficult to intervene at that point, right? Just because things happen very quickly, someone gets taken into an ER, they just automatically do what they're gonna do to a certain extent. But inevitably, there will come a time at which, right, we are transitioning from emergency care to whatever this is gonna look like next. And at that point, the power of attorney becomes very helpful in making whatever the decisions are. When we are talking about prolonged medical care that's sort of culminating in decisions about life-sustaining support and that sort of thing, absolutely the power of attorney is probably going to be useful. That's assuming that, all of this hinges on whether or not the person receiving care has the mental and physical ability to participate in the decisions about their care. So the assumption is, particularly when we talk about DNR, that's a moment at which a person physically is no longer able to sustain themselves. They are no longer able to do anything, much less give nuanced medical guidance to doctors, right? And so then the people who have the medical power of attorney absolutely are empowered to step in and do what they think is appropriate. It is, I think, as you described, a very difficult sort of transitional moment in a lot of cases, right? I am not surprised to hear that folks are not quite as certain about what they want in those moments, and that can be really hard, which is why things like a power of attorney can be so helpful, because if nothing else, what it automatically can do is essentially create an identified team of people who are with you in making those decisions, right? And so you don't have to feel like when you're receiving medical care, you have to make this decision alone. Nobody else can tell you what to do. Nobody else can help you with that. The reality is that as long as you have that power of attorney, you technically have more than one person, 2, 3, however many people it is, that you can talk to about this and sort of say, this is what I think I want. just so that you know, are you going to be able to tell a doctor that, and that sort of thing, because that's the other side of it, is that people who are empowered to make those decisions can, in the same way, become deer in headlights when it comes time to sort of speak up and say something. But I think all of these documents are intended to solidify a network for folks and the roles of folks within that network, so that at a moment when traditionally, I think in a lot of ways it's thought of as a very solitary thing, dying, right? Like it's your own experience and it just sort of happens to you and everybody else stands around and watches it happen and, there's no stopping it. It solidifies for everybody this idea that we are sort of all in this together and going through this process, whether it's decisions around medical care or whatever it may be. But yes, that is a long answer to a short question, but yeah, the power of attorney would be sufficient. If you don't have the power of attorney and you have the living will or the DNR, that speaks for itself. It's a whole other thing if you've got somebody who has a power of attorney and you've also executed a DNR and the person who has power of attorney doesn't want to follow the DNR, that's a whole other thing.
Right.
But typically what should happen in that case is that the DNR from the person receiving medical care should be what gets followed regardless of what the person with power of attorney wants to do.
Right.
So, yeah.
That's really helpful, thank you, because it is like exceedingly complex in weird ways, like you thought it was gonna be really simple, and it's not, so.
Yeah.
That's great, thank you.
I have a question for you.
Yeah.
So where do these get filed, or do they just get held in someone's house, or how does that work?
Yeah, so the funeral directive declaration, I mean, like any notarized act, doesn't have to get filed anywhere. The fact that it's notarized is what sort of makes it legally binding, right, in and of itself. If there is, I would imagine, if someone has made plans with a specific funeral home in advance, this would be a super handy document for them to have so that they know ahead of time exactly what's going on and what to expect.
That should, specifically giving your right of disposition.
Yeah.
Specifically, the document assigning your right of disposition should definitely go to the person who has your right of disposition. Also, you need to make sure that you have their consent. But then also, if you're going to prearrange, to make sure that that goes in your file at the funeral home, so that when you pass, the people who need it have it. But the will, not so much.
Yeah. So the second document that we have, the sort of living will declaration. It's technically sort of a medical directive. So some folks, depending on the type of medical care that you receive, you can ask if a doctor is able to include some sort of notation about it in your chart, in your notes, just so that, when your care gets transferred from one person to another, technically there's a note about it. It is not, in the same way that the LA Post document is, it is not a medical directive, right? So even if there's a note about it in your charts, no doctor is obligated in and of that to do what it says. Someone is still gonna have to have a copy of it. Somebody is still gonna have to give that copy or make that copy known to folks who are giving medical care so that they know that that's what they're following. And again, also, even if you ask your doctor, can you make a note in my chart that I have this thing, they may not actually do that. They may say, that's not really medical information. The chart is just supposed to be your medical information. I'm not gonna do that. So again, having folks informed about it, having folks have copies available, know where the copies are, all that sort of stuff, should be part of a plan to just sort of have these things identified and organized to a certain degree.
Great, thank you so much.
No problem.
All right, well, thank you everybody for coming today. And if you have any further questions, you can reach Wake, you can reach me at this email address or Wake at this phone number, and we can help connect you with some of these documents. And also we make referrals for legal services, bereavement support, all kinds of different needs that people are experiencing when they're dealing with death and dying.